They have the weapons to do the proceedings with ease. And the weapons are so powerful that I can guarantee, and I will too, my friends, I will guarantee that everyone hearing me read this article is a felon. That's right. You listening right there, right now, are a criminal. And if a federal prosecutor targets you, then you're going to prison. You might not have robbed a bank or stolen anything or engaged in any of the 10,000 quote-unquote crimes that federal prosecutors have in their buffet line, but I can guarantee you that you are guilty of, quote, honest services fraud, end quote. Have you ever taken a longer lunch break than what you were supposed to do? Have you ever made a personal phone call at work or done personal business on your employer's computer? Have you ever had a contract dispute with an employer or a client? All of those things and more can be criminalized by an enterprising federal prosecutor. If you're an attorney and you've signed forms even though you've not read every word of them, for example, the standard closing documents for real estate, then you have committed honest services fraud. The list goes on, but most likely by now you have the picture. You are guilty, even if you never are placed on the dock in a federal criminal court. As one person intimately familiar with these kinds of prosecutions told the author, quote, "This is better than RICO." And the RICO statutes have been proven to be one of the ultimate weapons used by federal prosecutors. Just the threat of invoking RICO can make even tough defendants turn into pliable putty ready to plead out instead of going to jail. Everyone listening to this can, without too much massaging here, be massaged into this little statute. There's another huge problem with this law, if we can dignify it as such by even calling it a law. Its vagueness and broad interpretation permits federal prosecutors to engage in tyrannical selective prosecution. When a law is so broad that nearly everyone who provides any services has broken it, then prosecutors are able to target people who might be politically unpopular. Honest services fraud has become the ultimate prosecutorial weapon, and prosecutors are quick to declare their support for it. According to the Wall Street Journal, quote, "Prosecutors love it." Patricia Pileggi, a former prosecutor who has brought honest services fraud cases, says, quote, "Since you don't have to prove loss of money, the statute is easier for prosecutors to use than extortion or bribery statutes." In fact, this particular law, first passed by Congress as an amendment to a wire and airmail fraud statute in 1988, allows federal prosecutors to do what prosecutors have always dreamed of doing: circumvent constitutional protections against the accused by both creating what essentially are bills of attainder and ex post facto law. Allow me to explain. First and most important, the law itself is vague. According to the statute, Congress has criminalized a, quote, "scheme or artifice to deprive another of the intangible right of honest services," end quote. But how does one define honest services? And who is deprived? Those questions are answered by prosecutors seeking indictments and convictions, and it is they who decide what is criminal and what is not. Although the questions of guilt ultimately is supposed to be left to a jury, the very presence of such broadly interpreted criminal laws with draconian penalties of 20 years or more in prison will lead many innocent people to plead out to something, because the risk of going to trial is too great, because federal prosecutors see their job as being a hammer, and they see everyone else as a nail. And it's clear that the loose and vague language in the statute involving an intangible right to services of others is an open-ended invitation for prosecutors to craft charges around whatever alleged act they wish to criminalize, even if the act itself is legal. That's the very essence of a bill of attainder. Second, because all too often an act is interpreted as being criminal after the fact, in essence, prosecutors are able to go back to an act that everyone believed to be legal and effectively apply a criminal statute to it. This is the essence of ex post facto law, which is unconstitutional. So when it finally hits the Supreme Court, it'll be unconstitutional or revolution. I'm going to make a prediction. I don't make very many predictions on this show here, but I'm going to make a prediction. And the prediction is this won't ever see the Supreme Court. It just won't. Because you see, so far, everyone who's been charged with it has never been convicted of it. They've all been convicted of other charges, lesser charges, so they wouldn't go to trial on this particular issue. Because this issue renders a 20-year sentence. So they'll threaten you with this issue with a 20-year sentence and say, but if you plead to this lesser thing that only has a 5-year sentence, and then you're like, oh yeah, okay, 5 years, okay, I'll do 5 years. That's a lot better than 20 years. And then you agree to a 5-year thing. So it's back to that old voluntary conviction. You see, back to Jeffrey Skillings, like I said, prosecutors were able to convince jurors that his actions were criminally fraudulent, although Victoria Sprouse was not charged with honest services fraud when she recently was railroaded into federal court. Nonetheless, federal prosecutor Matt Martins told the jury that because she had admitted to not reading every word in every by-the-numbers legal document she signed, she had committed honest services fraud. Now, if someone like Martins wanted to launch criminal prosecutions against professional people for not reading documents they sign, why is he not bringing criminal charges against members of Congress who rarely read bills that either they approve or vote down? For example, John Conyers of Michigan recently caused a stir when he admitted that he did not read bills before him. So here is a lawmaker openly admitting that he did not read legislation, and he hardly is alone. Few, if any, members of Congress read the Patriot Act or the Sarbanes-Oxley Act before approving them overwhelmingly. There is no substantive difference between what Martins deems as fraud with Victoria Sprouse and what the nation's elected representatives do every day they are in session. In fact, one could argue that at least Sprouse knew the substance of the documents before she signed, Many senators and representatives cannot tell their constituents the content of the legislation before them. Yet Sprouse is going to prison, and members of Congress do not have to worry about prosecution, at least for violating that statute. My friends, the rest of this article lays out an excellent case for you, the listener, to bring your own criminal charges against elected officials, against prosecutors, against judges, against law enforcement types, etc., etc., when they have committed honest services fraud.